afternoon, as I've said, or good morning if you're on this side of the country, and welcome to Perspectives on Land Use and Planning. My name is Victoria, and I'll be moderating today's panel. As we're all tuning in from across the country, I'd like to acknowledge the territories on which I'm calling in from today. I'm currently located in Victoria, BC, the traditional and ancestral lands of the Lekwungen peoples. We have three amazing speakers to hear from today, all of whom will address how agricultural lands are managed and regulated in Canada. They'll speak to how we protect and designate agricultural lands and some of the challenges that urbanization and succession planning can add to this complicated matrix. So we'll hear first from Jacob Damstra, a partner with Learners LLP, who operates out of their London, Ontario office. Jacob is a regulatory litigation and appeals lawyer practicing health, environmental, and municipal law in administrative tribunals and courts. He advises agricultural clients and landowners regarding contract disputes, environmental issues, and land use planning. He's also a director with Urban Roots London, a nonprofit urban farm that revitalizes underused land in the City of London. Jacob's presentation will center on two interrelated, contradictory, and problematic trends: urban sprawl and underutilization of urban land. And I'd like to note that Jacob will have to leave shortly after his presentation. So if you have any questions, we'll take them immediately after, and then we'll move on to David O'Connell, our second speaker. David is a professor in economic science and management at the University of Northern British Columbia. The research centers on agricultural land use planning to protect farmland, with related publications in the areas of plan evaluation and planning theory. David will speak to BC's agricultural land protection mechanism, namely the Agricultural Land Reserve, or the ALR. David will address some changes and changes back with respect to this land management regime. And finally, Jenna Corey-Hanna will be our third and final speaker. Jenna is an associate at Kinch Eddy Litigation Professional Corporation, a full-service litigation firm located in Campbellford, Ontario. Her civil litigation practice consists primarily of planning and land use issues, and Jenna will walk us through some of the work that crosses her desk, and specifically estate and succession planning issues for farms in Ontario. So without further ado, I'll turn things over to Jacob to kick us off.
Perfect. Thank you, Victoria. I am just going to put my slide deck up, and everybody should be able to see it now. Victoria, thumbs up, we're good to go. Awesome. So as Victoria outlined, we've really got a potpourri of topics involving the way we think about use of land and growth of food, where we grow food, how we use land. And I'm going to start us by talking about this emerging concept, this emerging idea of urban agriculture. And the subtitle here is Revitalizing Underused Land and Land Use Law and Policy, because we're able to look at it from both perspectives. We're not just revitalizing underused land within city limits, but we also need to revitalize the way that we that we organize land use law and policy. So this is what I'm going to cover. The outline is there. And as Victoria alluded to, what I'm going to address is this this trend, or these two trends, which I think are interrelated but contradictory, and both are problematic. And that's urban sprawl on one hand, and the underutilization of urban lands on the other. Urban sprawl sees the rapid expansion of the geographic extent of cities and towns, typically characterized by low density suburban residential development in historically agricultural land. On the other hand, we see the underutilization of significant tracts of publicly or privately owned land within city limits, which remain vacant or underused. Meanwhile, food deserts in urban areas are becoming ubiquitous. while carbon-dependent food supply chains are becoming more protracted and less equitable. So in this presentation, I'm going to explore how municipal planning law, in Ontario at least, and policy might be revitalized to allow for this underused land within the cities to be converted and used for agriculture. I'm going to look at a case study from an organization in London called Urban Roots London, and I'm going to look at reorientation of planning policy, municipal zoning, and the official plan in the City of London to think about how we might change environmental and agricultural framework, regulatory framework, as well as societal expectations towards urban agriculture, so we can begin to address these problematic trends. I don't think we're going to be able to reverse them. So the point of this presentation is to open a discussion on how we might be able to change the way we think about where we grow food and how we distribute it to incorporate it into the systems that we have. So first, let's frame the problem. And I'll try not to be super heavy on the food and agriculture related puns, as hard as I might try. There's going to be some that slip in there. And so what I'm going to talk about are the pests and the pressures that our food systems face. The first side is food production. Where we produce food, we have this increasing pressure, as I talked about, of expanding suburbanization of traditionally agricultural lands. In Ontario, there's big news coming out in the last couple of weeks, which will have a significant impact on Ontario's land use planning policy. We've all heard now ad nauseum, I think, about the housing crisis that apparently exists, and Ontario's mandate to build 1.5 million houses in the next 10 years. This is only going to intensify what we're already seeing with suburban sprawl and the destruction, degradation, and conversion of agricultural lands for residential purposes. And with that, industrial areas will expand and we'll be left with less area to farm. One example of that that sort of came out in the last couple of months is Peel region and Halton region, both in the GTA, combined in the last couple of months have announced that they are going to expand their urban growth boundaries combined by about 22,000 acres. So in the next 25 years, 22,000 acres of agricultural land in those areas will be converted for urban growth and housing. And I think that that's only going to increase everywhere across the province as municipalities are pressured and forced to convert more land for housing. The second pest is the food supply chain issue. And depending on which statistics you look at, between 2/3 and 80% of Canada's fruits and vegetables are imported from outside of Canada. This adds increased food waste as food spoils on trucks, which leads to increased emissions, but it also has increased greenhouse gas emissions in our food supply chains, meaning that every piece of fruit or every vegetable that we eat has been transported from somewhere else on a truck or on a ship that has burned fuel in order to get to your table, which is a significant problem. And then the third and related pressure is the inflationary pressure that we're all seeing and facing right now, which is continuing to impact food access and affordability across Canada. And combined with this, the proliferation of food deserts in urban areas. And just briefly, a food desert, and I'm sure that many of us who are interested in attending this type of conference know what that concept is, but it's an area typically in an urban center in a city where there's a lack of access to to fresh food because the grocery store is too far away. It's usually a lower income neighborhood where people don't have the ability to to access a vehicle, and so they're less able to attain food. The traditional way of thinking is another past in this system. And the traditional way of thinking, I've got the photo credit, but I don't have the photo yet, I think is really well encapsulated by this image. And I'm sure that we've all seen this in Ontario-based not-for-profit that called Farmers Feed Cities, which advocates for farmers' rights. But this image encapsulates the food is grown out here and we live in there, or we live in where the food is grown out there. It's the city country divide. It's the us and them approach. It's the fact that agriculture is something that's done away from where we live. Food is grown somewhere and it's shipped in and it's put on a grocery store. And of course, that hasn't always been the case, but that's certainly been the case, in the last 50 years, and increasingly more so. The problem with that traditional thinking is that it creates an artificial divide or an artificial separation, and it makes us think that it's only agricultural land out in the country that is suitable for and appropriate to grow food. And it reinforces that issue of as we continue to expand housing outwards, eating up traditionally agricultural lands, we have less lands on which to grow food. And it prevents us from looking at lands within cities as viable options for addressing a number of these problems that exist. So that's the traditional way of thinking. And one very powerful quote that I like to sort of think about is that we cannot solve our problems using the same level of thinking we used when we created them. This is attributed to Albert Einstein. I think that, I don't know if he's ever actually said that, but it's been similarly stated that no problem can be solved with the same consciousness that created it. So what this presentation is about changing the level of thinking that we're using when we're looking at land use planning and agriculture. It's about elevating our consciousness beyond the us versus them, the here versus there, and having an integrated approach to how we grow, distribute, and enjoy food. And that's where this idea of urban agriculture comes in. So here's an image from the organization that I mentioned, Urban Roots London. And there's a few more that will give you a better sense, but this is an urban farm within the heart of the city of London, right along the main highway inlet corridor, which is right in the middle of a food desert in our city, which grows food to be distributed equitably to members of the community and throughout the city. And I'll get more into Urban Roots as a case study. But the idea here is that we're revitalizing, we're rethinking, we're changing our level of consciousness when it comes to how we produce and distribute food at a hyper-local scale. We're offering an alternative model and thinking to test, to prove, and then ultimately to germinate to new sites across London, as well as other cities. So here are some of the barriers which I think exist in traditional thinking to land use planning and zoning to breaking new ground with urban agriculture. At a high level, because I know that we're not all from Ontario, the way that land use is regulated is at the provincial level through the Planning Act, which then delegates responsibility to individual municipalities to create official plans, which say where you can do certain things, and zoning bylaws, which regulate the appropriate uses in certain zones. Very high level land use planning overview. But the problems or the barriers are that our official plans are outdated, and that goes back to the traditional thinking. Agriculture is not clearly permitted, and in most cases actually prohibited in urban areas. Whereas it's has to be in land zoned agricultural to be able to grow and distribute food, whether that's produce or raising poultry or livestock. Official plans are what permit landowners to do certain things. And if the official plan is in that old way of thinking, then it's much more difficult to use that underused urban land. Zoning bylaw restrictions similarly typically include restrictions on the sale and distribution of produce, including urban grown produce. And some are restrictive by omission because it's not permitted, whereas other zoning bylaws are restrictive by express prohibition or restriction. For example, prior to changes that I'm going to talk about in the City of London, people who chose to grow food in their own backyard in a residentially zoned area couldn't sell that produce. Then there was some changes to allow them to sell it a couple of times a year. And now more recently, there's been changes to allow people to grow and sell or distribute produce that they grow a number of times a year, subject to certain conditions. There's also infrastructure limitations, either through an official plan or zoning bylaw or other regulatory regimes on the production of food on an urban level. And so this limits food production on a meaningful scale. And we're talking about something that's a little bit bigger scale than a backyard garden, something that might utilize a greenhouse structure, something that might utilize irrigation system, which may not be permitted under the existing zoning bylaw or official plan. And then there are land access impediments. This is a big issue for people that want to produce and distribute food more sustainably, perhaps on an equitable model, but that might not have ownership to or access to land in order to do that. So Urban Roots London is the case study that I want to talk about. It's a not-for-profit organization in the City of London that is dedicated to revitalizing underused land, producing high-quality, organically grown vegetables, herbs, fruits, distributing them locally on an equitable model, developing agricultural opportunities for employment, for education, and for partnerships with other organizations, and growing a self-sustaining model that can then be germinated out to other sites. Urban Roots has committed to sustainable production and equitable distribution. So what does that mean? We started with a 1/4 acre in 2017, and it's now grown to about 3 acres, just a little bit less than 3 acres of total production, 3 different sites across the city, and a couple of consulting sites, including in neighboring First Nations reserve lands to bring back food sovereignty into our Indigenous communities. It's sustainable, biodiverse, intensive growing, which allows us to grow a lot of food in a small area. And when I say us, I'm a director of the organization. So I'm sort of volunteering and overseeing governance and legal issues, but not the one actually doing the growing for the most part. So over 5 years, the organization's produced over 40,000 pounds of food distributed directly into the community with almost zero food waste because it is going direct to consumer without shipping. And in 2022 alone, there's been more than 20,000 pounds of food produced, and we're on pace to grow and sustainably grow more than 25,000 pounds of food per year on this very small area, which is a significant amount. And we're able to partner with other food-based social enterprises, community resource centers, to handle the distribution of food direct to consumers in these food desert areas, in these lower income neighborhoods, to allow us to to not worry about the distribution. We operate on a model of thirds, and what that means is that 1/3 of what's grown is donated, 1/3 of what's grown is sold at affordable or accessible rates, and 1/3 is sold to restaurants or grocer partners at wholesale rates to allow them to use in their meals or on their shelves. Meanwhile, as I said, Urban Roots started in 2017. The same year, the City of London created or stood up an Urban Agriculture Steering Committee. And so had membership on being an organization that was doing this work. And through that trial and error of what we were doing, we helped to shape the policy that the city was putting in place in terms of urban agriculture. So we started doing this before it was allowed, and then used what we were doing as a model for the policies that would be put in place. That was through engagement with local municipal staff, as well as elected councillors at the municipal level, as well as the Ministry of Environment, Climate and Parks at the provincial level, regarding on-site composting to allow us to create our own compost. We launched a program for community composting, which allows people to bring their food scraps and food waste to the farm areas to be composted and used, creating a full life cycle. If they come to get their groceries from the farm at our farm gate sales, they go home, they eat it, they bring back whatever scraps there are, it's composted, and it's used and applied to the field. Through the work on the Urban Agriculture Steering Committee, we helped to craft an urban agriculture strategy for the city, which was adopted. And part of adopting that strategy included amending London's official plan, the London Plan, which has very comprehensive policies on planning for local food systems and permitting more use of underused land, city-owned land for urban agriculture, either on this type of model, on a for-profit model, or on a community garden model. There are also a number of zoning bylaw amendments that we've been able to achieve to allow for site-specific urban farm zoning for certain areas, defining and allowing farm gate sales within urban areas, and also, as I said earlier, changing the permissions for household sales. There's also zoning bylaw amendments in place which allow for residential zoned properties to have small greenhouses or sort of micro infrastructure. So this sort of last piece that I think is necessary is to take these sort of small wins in one area and expand them to the provincial level, expand them to other municipalities. And so there are a number of opportunities for revitalizing land use policy. In Ontario, as I said, we're sort of under the Planning Act. And there are a couple of opportunities for incorporating urban agriculture into our Planning Act. One, as a condition to approval of plans of subdivision under Section 51, subsection 25, municipalities or approval authorities are able to impose a number of conditions on would-be developers in asking for a plan of subdivision. One thing that we've started to have a conversation with at the City of London is, why not impose conditions on developers to preserve a portion of the area to be developed for agricultural purposes, either for community garden that the buyers of these houses could enter into, or city managed or developer managed or private organization managed urban farm that could then sell directly to that community within walking distance. There's a parkland dedication section of the Planning Act, which allows approval authorities to require an area of the to be developed parcel for parkland. That could be easily adopted to allow for dedication of urban agriculture area. Some of the other opportunities are at a local level, advocating for official plan, zoning, or site plan bylaw amendments, or advocating for creative interpretations of existing municipal bylaws to allow for urban agriculture. And then finally, thinking about the way that we deal with municipal assets, municipally owned lands, city boulevards, street corners, parklands, dedicating or advocating for the dedication of a percentage of municipally owned lands for food production to create local sustainable food systems. I've got on my slides, which I understand will be available somewhere, a number of examples from the London plan, which is the City of London's official plan. And I won't sort of read them all, but I'll click through them because I want to sort of end here and have an opportunity for some questions if there are any. But what I would highlight is that the City of London has committed to creating and fostering a sustainable local food system through rethinking about the way that municipal parks are organized, by allowing for the imposition of conditions on developers, for example, in policy to use public or parks and open spaces to support food systems is an important one. And by actually defining food systems, identifying their importance to our future, and setting goals and an action plan for how those goals will be achieved in creating, fostering a local food system, including this amendment, which we were able to achieve in the official plan specifically for growing food in urban areas, allowing for municipal investment in urban agriculture, allowing for greenhouses to be used, for example, in residentially zoned areas or open space zoned areas, allowing for growing of food in converted shipping containers in urban spaces. All of this, I think, is necessary to break free from that mold of the traditional way of thinking and to reimagine the way that we engage with, grow and distribute food. And again, talking about public-private partnerships and city investment in a sustainable, dynamic local food system, as opposed to food is grown out there, it's shipped in here, and this is where we eat it. It's about growing it here, distributing it here, engaging members of the community in that process, and getting back to our roots. Again, pardon the pun. So that's a really high-level overview of work that we're doing in London with Urban Roots, as well as with the City of London's official plan and zoning bylaw. I would be happy to answer any questions, but also happy to receive any emails or calls from folks who are watching this after the fact, who are interested in starting an urban farm, changing their own municipality's policy. We're working on a starter guide or a how-to guide, both from a shovels in the ground perspective, as well as a words on paper regulatory policy guide for folks all across the province and hopefully all across the country. So Victoria, over to you to sort of field any questions, and I'm happy to chat a little bit more.
Thank you, Jacob. That was a great presentation, and I see we've got a couple, and I think maybe the first that I would raise is Alyssa's, and essentially she's asked if you can talk about your strategy for pushing law and bylaw reform. And I take it that maybe the Urban Roots Farm was a bit of a test case, if you will. You said you were in communication with municipal governments and councillors, and I guess it wasn't necessarily permitted at the time, but you pushed it through. And I wonder if, that's probably part of the strategy, and you have to have those communications, but some of it is action-based. So maybe you can provide a little more context about those relations. And
yeah, exactly right. I think that you said it well, that part of it is action-based. It's proving that this can work. And as I said, the first season, it was a quarter of an acre on that larger parcel that we have. So it really wasn't a significant change, but it was to prove that we could grow food on a sort of hyper local, very intensive scale, and that there was a demand for access to locally grown food. And it was a continuous conversation. So that was the action-based part. We just started doing it, but it was also in consultation with municipal staff, finding the champions within municipal staff who wanted to see these types of things happening, working with them, having an open conversation about what we were doing, why we were doing it, what would be permitted, what wouldn't be permitted, how we might change or request amendments to the bylaws to make it permitted. And so it was sort of always in a staged approach where we were doing, but then we continued to expand and grow what we were doing in order to allow us to do more and more. And as I said, that now includes growing at our main site, which we own, and then entering into partnerships with a local church, with one of the hospitals in London, with Indigenous communities to expand or convert some of their area into that growing space. So it's a constant conversation. I mean, getting your counselors involved to direct staff to do this is important, but working directly with staff in a cooperative way, I think, is the approach, as opposed to we're going to do this because we want to do this, and I don't really care what you say. I don't think that's the right approach here. When you're trying to change the mindset, you're trying to change the way that we think about things, doing it in that collaborative, cooperative nature, I think, is best.
Yeah, and it does sound like there's a lot of elements of proving every stage and sort of going slowly up the ranks, and you get more credibility the more work that you do, and it does sound like a staged process. So maybe I'll hand it over to Jacob to quickly ask a question, and then I'll turn to Jeanette's question in the chat.
So I don't know if many people in the audience have an interest in legal history, but some of the first zoning bylaws in industrial England and Scotland were actually to push agriculture and especially livestock food production out of cities. And so historians have talked about how that resulted in like a breakdown in understanding between producers and consumers about where their food comes from. So I was wondering if that's something that urban roots or other forms of mixed agriculture and urban environments can help educate consumers and bridge gaps that exist between production and consumption.
Yeah, I mean, and that's part of it is creating agricultural opportunities in employment, in education, in volunteerism, re-engaging people who live in cities with the way food is grown and how it's produced. And I mean, one thing that I don't think I said expressly, but it might have been implicit, is that we don't raise poultry or livestock in this urban setting. We do have bees, for like honeybees. We do have sort of on-site composting, which is done in a way that minimizes, sort of odor and impacts on neighbors. But it's about that re-education, that reconnection with people by inviting people onto the space, both to access food, but also to be involved in the growing of it, is an important piece. And I think that that's part of the conversation as well, is not just with the decision makers, but also with the communities in which you're operating, so that you can get their support as well.
Thank you. And then I'll turn to, I know you probably have to run shortly, but I'll just throw one more question from Jeanette from the chat. And I think David and Jenna may be able to speak to this as well, but whether or not there's something similar to the Agricultural Land Reserve in Ontario, or some similar mechanism for protecting agricultural lands.
So in Ontario, our Planning Act requires municipalities to make planning decisions in accordance with the provincial policy statements, which are released by the province and updated from time to time. Our provincial policy statement currently has a commitment to, or an instruction for municipalities to preserve prime agricultural land. Whether that's followed or not consistently is, sometimes problematic, but there is that sort of statement of commitment to preserving agricultural land, directing development away from prime agricultural land. And perhaps Jenna can speak more about that in answering questions, but it's not a, I mean, it's not a strictly enforced policy by any stretch. And as I alluded to earlier in my presentation, regions or municipalities have urban growth boundaries that they set for 25-year growth projections, which often just creep out further and further into agricultural areas. And then something that's zoned future development can just be applied to be converted into housing development, even if it was very productive agricultural land beforehand. So it's not a great system. And I think there's a lot of work to be done to preserve agricultural land that we have. But that's why I think we also need to rethink, and we need to think about how we can grow in urban areas as well.
Okay, and I might sneak in one additional question that I sort of have, because I know that Urban Roots operates on a nonprofit basis, and you've indicated that maybe there's room for profit structures to sort of take up what's been going on there. And I guess some red flags go off in my mind sometimes with respect to like co-opted market share and people just looking to, I guess, larger businesses maybe looking to enter into niche markets or do things a little differently, and whether that could sort of push up costs to consumers and maybe even move the food out of the city from which it's grown in a way. I don't know if that's a concern that's come up, or if you feel that that's not the direction this will go.
It could, but I think that a part of the profitability, and as I said, we're on a not-for-profit model, but if you were to do it on a profitable model, then I think doing it on such a small scale, you need to be direct to consumer or minimize your shipping. So the transport of the food out of where it's grown, I think, would defeat the purpose and also defeat the profitability. Whereas doing it at a small scale, I think that it's very possible to use 2 or 3 acres or smaller and have for one person to have a sustainable model. I mean, we're not talking about multiple 6 figures, but we're talking about producing and having a meaningful way of life and connecting directly with the people you're serving. So I think that there's enough there in terms of the inherent limitations in the model that you won't see the mega corporations coming in and buying up all of the small parcels in order to farm and profit. I think it's going to be more of a grassroots movement, and it has to be in order for it to work.
Yeah, that makes a lot of sense. They sort of lose the profitability aspect if they're moving it too far and they're trying to impose big business ideas on this model.
For sure.
Thank you very much.
Thank you, Victoria.
And so I'll now pass things over to David to speak to us about the ALR.
Thank you, Victoria. I'm just going to share my screen. And that should be working. Yes, thank you, everyone. Yeah, it's good morning in my end of the country as well. So I'm going to be speaking to just lessons learned from a major policy change in British Columbia. So mostly, well, I'll explain, I guess, immediately here. In 1973, British Columbia established the Agricultural Land Reserve, or ALR, and for most of that time, right up until 2014, it was a single zone. So the single zone in terms of all agricultural land, which is basically identified here as the green areas, was designated for agricultural land use. And a commission, Agricultural Land Commission, or the commission, was established at the same time, and it receives applications from landowners as well as local governments for things like subdivision, non-farm uses of land that are not permitted, or things like excluding land or removing agricultural land from the ALR. So that commission is a quasi-judicial body, also established by the Agricultural Land Commission Act along with the ALR itself. When making decisions, the commission is to, this is from the Agricultural ALC Act, The considerations are these, and this is section 6, and primarily what it comes down to is that when making decisions, the commission basically has this single purpose of preserving agricultural lands. That's its overriding purpose, and then it looks at every application by its own merits. So that's the way it had been since 1973, so a single zone agricultural land reserve, and commission with a pretty straightforward set of considerations within that mix. So in 2014, the government introduced a 2-zone system. And this here we have in the peachy type color. Zone 1 was considered the more productive agricultural land. And then zone 2, which covered most of the province, it was considered less valuable or less productive agricultural land. So this is the media release that the government sent out when it the amendment Bill 24 was approved. And this captures the essence of what they wanted to talk, what the reasons, the rationale. So just reading this for everyone's benefit, the improvements include the creation of 2 administrative zones to better recognize the province's regional differences. In zone 2, where growing seasons are shorter and there are lower value crops, AL decisions will now, in addition to the original principle, will include additional considerations to provide farmers with more flexibility to support their farming operations. And it's these additional considerations that were a key element, the key element of this Bill 24. So this is section 4.3, which was added to the Act. And it's, as you can see here, it's specific to zone 2. So zone 1, which is that more agricultural land, was still guided only by section 6. But now in zone 2, when the commission received an application, it had these additional considerations under B, C, and D. And of these, economic, cultural, and social values are really, I would say, the novel, the unique contribution that Bill 24 made. And that really was in a simplest, oversimplified version of the question that we were pursuing and interested in. It was, what influence did section 4.3b have on the commission decisions? So, excuse me, thus began our journey. We did extensive analysis and we looked at decisions made by the commission. And I've already forgotten the numbers. So between 300 and 400 different decisions. And those, each decision letter, so this was, the application would come in, but the decision letter, which was at the end of the process, included a lot of that application information. The ALC, the commission, did an assessment of the parcel and then issued a rationale. So this is just a rich source of information for us, and it was our primary unit of analysis to gather the data we wanted. So we looked at it over 2 periods. In period 1 was 31 months prior to, under the single zone, but the period prior to Bill 24 coming into effect. And then period 2 was for 49 months. And that was when the 2-zone system was in play. And in 2019, another government came in and changed the ALR back to a single zone. That's a subject of another set of analyses. I'm just focusing on these 2 periods here. So the time before and then the time during the 2-zone process. This gives you a sense, some sense of what we looked at. Due to time limitations, I won't be showing any of the data analysis, the results of our analyses that we did, but we did a lot of analyses. What you're looking at here is just our kind of the starting point where we have P1, P2, the 2 different periods. And within British Columbia, the commission is divided into multiple zones. And we looked at 3 of the zones that cover most of zone 2. I'm calling them zones. They're actually regional panels. So each regional panel had an appointed members who would make decisions for that panel, for that region. The regions were different sizes and the periods were of different lengths. So we actually normalized the data. So what you're looking at here in that 2.69, for example, refers to rates of applications submitted per 1,000 farms per month, and then bumped up to a year actually. So it's normalized numbers so we can compare across periods and across regions. So we did extensive analyses. We looked and looked and looked at the aggregate levels. We looked whether applications were approved or refused. We looked at types of applications in terms of subdivisions, non-farm uses, and exclusions. We also considered agricultural capabilities, so the CLI classes, if you're familiar with them, but the best agricultural land, the secondary agricultural land, and then if the parcel's mixed. So we did lots of analyses. And in the end, at that aggregate data level, we found some interesting things that pointed at some possibilities, but nothing was really discernible where we could really say with confidence that Bill 24 at this aggregate level had an influence on commission decisions. And so we had to keep looking, and we got quite creative and just delving down into subsets and then additional subsets in order to find some concrete evidence that Bill 24 had influence. And this was really our first step. We definitely expected to see something at the aggregate level, and in the absence of, it set us along our journey. And on the way, certainly we were picking up flags, and we literally flagged them for further analysis. So what I'm going to do is really jump to the end of our analyses, where we looked at these particular decisions that fell under section 33.1 of the Agricultural Land Commission Act. So it gave the authority to the commission chair to reconsider a decision that was made by the panel. And specifically, this was added specifically under Bill 24, but the chair could reconsider a decision of the panel if the chair felt it does not adequately take into consideration the consideration section set out in section 4.3. So that's when we looked at these reconsiderations by the chair, this is where we were finally able to find some concrete evidence. So this is an example. It's an application 53851 to subdivide a 10-hectare parcel and for a retirement residence. So this is the North Panel's decision, and you can see here this is quoted then in the ALC decision letter. And it says that in this case, the panel members, two of the three panel members believe that the social, economic, and cultural values of the retiring farmer overrides the agricultural considerations of the application. So here's the explicit reference that we were searching for, where literally section 4.3b is cited as basically outweighing the mandate of the commission to preserve agricultural land. So this was, well, after spending months of looking, this was quite an exciting moment for us. The life of an academic. And this then is the executive committee. So when the chair reconsiders it, the executive committee of the commission then looks at the panel decision. And here highlighted, you can see that the executive committee believes that the negative agricultural impacts of the subdivision home site clearly outweigh the social and economic benefits accruing to the landowners. So in effect, what you have is really clear evidence that the North Panel cited section 4.3b, and then immediately the executive committee reviews it, reconsiders it, and just flips it in terms of, no, these additional considerations do not outweigh the mandate of the commission to preserve agricultural land. So this was, quite interesting for us. And it's just a summary of those reconsiderations by chair. There were 29 of them that we found, and most of those panel decisions, so 69%, were reversed by the executive committee. The overriding areas of disagreement were around suitability and impact. So not section 4.3, that was not the issue. So when the chair reconsidered, it would have been for other factors beyond 4.3b. And then there were a small subset, and I say perhaps because there's certainly room for interpretation, but maybe 5 of those 29 where section 4.3b could be identified as an influential factor that led to a decision that would have been based on section 4.3b, those economic, social, cultural values. But that's 5 out of, I apologize for not remembering the number, but it's 300 or 400 decisions that we looked at. So in the end, our overriding question was, did creating a 2-zone system make any difference in zone 2? And the answer is no, not on the land base and overall, not on the decisions themselves. Although we did see anomalies throughout, just interesting anomalies that came out, but certainly the North panel was one of those that seemed to be more inclined to use section 4.3b. And that begs the question in terms of why did this happen? And these are where the lessons learned come from. And I want to turn back to the media release, where a key concept, a key principle that they mentioned over and over, they being the government, was this idea of flexibility. So these new additional considerations were introduced in order to provide farmers with more flexibility so that they could earn non-farm income from their lands. And that strikes me as particularly interesting because the work I have been doing, and I've presented to the Food Law Conference before, where I've talked about these principles. I've used these principles to evaluate the strength of farmland protection policies at multiple levels of government across Canada. But I also used them in this case as a framework to interpret the meaningfulness, significance of the changes implemented through Bill 24. So I'm just going to review those relatively quickly. But this table just outlines some of the major elements of Bill 24 of particular interest to us in this study. So I'll start at the bottom here. And so I guess didn't explain the principles. So these are the short forms. So maximizing stability is just to have a clear commitment to protecting, well, I'll call it policy focus, whatever it might be, but a clear commitment to protecting agricultural land in the most important documents, in this case, the Agricultural Land Commission Act. Integrating across jurisdictions means that all levels of government needs to be consistent, and it should be, consistent level of commitment. But we all know that a lot of laws, pieces of legislation have loopholes and some uncertain language that lends to ambiguity and potential problems. And the fourth principle then is only after taking the care of the first three should one then consider flexibility. So those are the principles I had developed and have used, again, in different contexts, but all looking at farmland protection. For Bill 24, again, these are the main ones. I'll start by looking at the bottom here in terms of Bill 24 really was about introducing flexibility. They were really critical, they being the government was really critical of the one size fits all single zone with this one single set of considerations, which are rather narrow, at least in the Act. So they codified regional panels, which meant that prior to, the chair had discretion whether or not to set these panels and could use them largely, however, the chair believed it was best. It was codified, so they had to be in place, and that the principle here was that it would reflect those regional differences. And the other one was the new considerations under 4.3, which I've already talked about quite a bit. Through this process, though, the government said repeatedly that they would not change the mandate. So the mandate of the LC, that section 6, did not change. But here's the one thing that really flipped Bill 24 around and led to its ineffectiveness. Certainly, this would be my argument. So when Bill 24 was first introduced, so first reading, introduced to the Legislative Assembly, it stated the following. So this is all the same, in fact, except what's highlighted. It said the commission must consider all of the following. Now, prior to this second reading and final approval, it was amended so that statement was said that the commission must consider the following in descending order of priority. So you can see where by adding those words, it meant that section 6 under A took priority over the other ones. And in effect, that really reestablished the status quo. So in spite of all of the interest to introduce flexibility, under the first reading, as it said here in the highlighted yellow, if the commission had to consider all of the following, the ALC Act would have been a mess. That mandate to protect, preserve agricultural land would have been severely compromised in my position. But somewhere between first and last reading, then they added this amendment, and it fundamentally, in my view, flipped the Agricultural Land Commission Act. So that really is the primary lesson. And then in case there are some issues with section 4.3, they also have these reconsiderations by chair. And I imagine that this was done to support the government's interest in doing flexibility, but in fact, this reconsideration worked almost against those intentions, at least, and served to reinforce section 6. So those lessons then, there's that call for flexibility is dominant in certainly land use planning. Local governments, landowners always want more flexibility. So primary lessons, just briefly, is that flexibility should not, and I would argue cannot, be the overriding principle for policy development. It's not a helpful policy. And we can see how largely it can be ineffective at the provincial level through Bill 24. But uncertainty can undermine stability. So without that amendment, if they said that section 4.3 was considered all of the following, we can interpret that as just, even though they didn't change the mandate, it would introduce so much uncertainty that the commission's decision-making process really would have been just turned into turmoil. And then lastly, I would argue perhaps from my perspective only, but the 4 principles I do believe are really helpful tools. So I've used them to evaluate the strength of policies. And I've used them, I can certainly see them as guides to developing policies, but within this context, and certainly think it's relevant to the world of law, in terms of the principles can be used to interpret the significance and potential implications of legislative changes to such things like Bill 24. So with that, I will end and thank you there and turn it over back to Victoria.
Thank you, David. I'm teeming with questions, but I'll hand it over to Jenna, and then we can have our Q&A all together at the end.
Great, thank you. And thank you everyone for still hanging in. I know it's like the end of the last day of the conference and we're the last panel, and I appreciate you all being here. So I'm also gonna share my screen. All right, so I'm here today to talk about some of the farmland succession issues that I'm seeing in my practice. I feel like I have a habit of coming to this conference and being like, here are issues I see, and I have no concrete solutions to offer. And that's exactly what I'm doing here today, just to kind of preface that. So just a little bit about my practice. In her introduction, Victoria mentioned it, but I work at Kinchetti Litigation, and we're just a general full service litigation firm located in Northumberland County. And we're small with 3 lawyers and 3 paralegals, but we're actually one of the largest firms in Northumberland County where the firm is located, as well as we're actually the only litigation firm in the area. And we take on files in both all of Central East and in some of Central. So we do appearances primarily in 4 different courthouses. So that's been one good thing about the switch to Zoom, is a lot less time driving. And for those who aren't familiar with Northumberland County, I thought I'd take a little bit of time to orient you all, just because it's a part of Ontario that even a lot of people from Ontario aren't familiar with. And I'm from Nova Scotia, and I certainly wasn't familiar with the area before I moved here. So you can see Campbellford's right all the way up here. That's where I work. North of Northumberland County, we have Peterborough, and then to the west, we have Durham region, which is where Oshawa, Ajax, Whitby, all of that is located. And then to the east, we have Quinte West, and then we have Prince Edward County. The county has a population of approximately 85,000 people or so. And one thing of note, though, is that 31% of the county is prime agricultural lands. We have approximately 954 farms using 606 acres of land currently. And in 2016, those farms generated 113.84 million in farm cash receipts. So this is I think a small but mighty agricultural area in Ontario. And for that reason, a lot of our clients we see at the firm, even if we're not directly providing services in relation to them being a farmer or owning a farm, like most of our clients are farmers just because of the nature of the area. So in the last year or so, our office has seen an influx of farmland succession issues. The firm is about 7 years old now, and everyone else who's been there longer than I have keeps saying that the amount of files involving farmland succession is unprecedented and hasn't been seen before at our office. And And we're getting a lot of estate work involving farmland right now. So I would say I kind of did some thinking about the types of files we're seeing, and I can kind of categorize them into three broad categories. So first is problems stemming from interest in farmland passing on to all surviving family members equally. The second thing is certain assets not being dealt with adequately or properly in like a will, for example, which leads to disputes. And then the third is something like maybe a right of refusal being in a will, but the will doesn't lay out a process for the family to follow, and that leads to issues. And these are very, very common things that we're getting calls about, I would say, weekly at our office right now. So too many inheritors. So I have been seeing an influx of situations where as many as 5 people are inheriting an interest in a property. And I actually have one file where I have 7 people who all inherited as tenants in common an interest in a piece of farmland. And there's a lot of issues that arise from this, just practically speaking. You're putting a bunch of people into a co-ownership arrangement where, in my experience, that's not being discussed beforehand. Maybe family suspect the farm's going to pass on to someone, and then it's a surprise when it turns out it's passing to all of them equally. And because of that, there's no discussion ahead of time of what that co-ownership will look like. And so there's no co-tenancy agreement in place that provides any guidance. There's fundamental disagreements about what should happen with the land now that they're all co-owners. And then there's also disagreements as to who should bear the carrying costs of keeping the farm in the family. And unfortunately, in a lot of these situations, I end up going to court to bring a partition act to request that the land be sold, which is really unfortunate because it means that the land is not staying in the family and it's getting sold to somebody else. But I mean, like, what are you supposed to do when you have 7 people or 5 people who all have ended up owning a piece of property together through an inheritance who can't fundamentally agree on what should happen with the land? And so it's problematic in that it frustrates the farmland succession planning that the farmer has attempted to do. But at the same time, I think like I don't do wills, but I think like I think as lawyers, we need to think about more practically what the effect or impact is going to be of that many people inheriting a piece of property together. So the next thing is assets not dealt with. And so a more common thing that we're seeing than you'd expect is farmer passes away. Farmer owns 2 pieces of property. One is joined with a child or another family member. The other piece of property they own solely in their name, and the will only deals with the property that's solely owned. And then you have a case where perhaps the child or family member says, there's a right of survivorship, and that's why I was joined on this farm, is so that I can inherit it. And then the rest of the family is saying, no, it should go into the estate. And this is something that could have been dealt with very easily in a sentence or 2, perhaps, in the will, to clarify that that's the intention with that piece of property, so it was documented somewhere. But because it's not, we're ending up in court. Other things that we're seeing are things like there'll be really general directions as to what to do with farm equipment, but it's actually unknown by family members, like what's actually owned, what's leased, what's been borrowed from neighboring farms, for example. And there's just insufficient documents for them to be able to sort it out. And then they call our office looking for guidance as to what they should do. And then the third thing that we're seeing is that there's not like interim planning. Like if someone's an active farmer and they pass away and they're in the middle of a growing season, like what happens? And so that's the other thing that we're seeing. Like, do you just, like, are the crops a loss? Like, is there a contingency plan, or should there be a contingency plan in place to finish out the growing season and then to liquidate those crops and turn it into cash to go into the estate? So that's another piece that we have people calling our office about. And then finally, another common thing that we're seeing is like a will, for example, will provide a family member who's still farming a first right of refusal, but it doesn't lay out a process or like, for example, what the value of the farm should be, or what does the right of first refusal include? Does it include the equipment located on the farm and other kind of farming related assets? And we're getting calls about this because either you have an executor who wants to sell the farmland way under value to try to keep it in the family and so that that first right of refusal can be exercised, or you have like they're calling and wanting to get advice on if that's a good idea or not, or we have other beneficiaries calling upset that a piece of farmland has been undervalued and they feel like the executor's duty is to maximize the estate for the other beneficiaries who aren't receiving the farmland. And I think it's worth noting, I feel like and a lot of the dialogue I've heard around succession planning, there's concerns that farmers aren't doing succession planning or that they lack tools to do succession planning. But in what we're seeing at our office, these are farmers who sought out legal advice and assistance in planning their estates, but that advice isn't being adequately tailored to the unique space that farmland exists in. And I really don't know what that special consideration should look like, but I just, based off of what we're seeing, I think that the typical type of estate planning tools that a lot of lawyers are taught in law school and that they would use for people who aren't farmers, they're not landing, and they're not having the success that we would hope to see. And I think it's really unfortunate to see all these farming families spending thousands of dollars in legal fees in order to resolve some of these issues in some instances, especially where there's deeply entrenched disagreement between family members. And like I said, I don't know what to do about it, but we're seeing a lot of it, and something needs to happen. And that's all I have. I have my email address here at the bottom if anyone wants to email me. I'm always happy to chat. Yeah, that's all I have.
Thank you, Jenna. That was great. So I don't see any questions in the chat yet. If anyone, oh, Jacob's got his hand up. So do as Jacob's done if you have a question, and then I'll just flip through everybody.
So yeah, Jenna, I was wondering, when you bring some of these motions for petition, is there any issues you run into, whether it be like nutrient management or some of the geographical limitations on livestock? So for like, I'm thinking like quota industries, for example, like if you split up land that dairy cows exist on, do you have any issues with that when you bring it to the court?
Yeah, so no, but that's because in those instances, I'm not specifically asking for petition. I'm just asking for sale of the whole property, and that being one of the considerations that is behind the request to just sell the whole property rather than splitting it up. The other thing in our area, the Northumberland County official plan doesn't actually allow, it's really, I'm like, how do I explain this? They don't like farms that are less than 100 acres. And so like also like our official plan, like and our planning documents also don't allow for farms to be split up in that way. So it just, yeah, whenever I'm bringing partition and sale applications to the court, I'm just asking for sale of the whole parcel and not splitting it up. And I'm just explaining to the court, like, it's contrary to our planning documents for it to be split up. It like, yeah, I have had a couple properties that I've had livestock quotas, and I'm like, this will mess up the livestock quota and cause licensing issues. So, and yeah, and in all of those instances so far, knock on wood, I guess, the court has just granted sale of the whole property and hasn't gone ahead with ordering that it be split up into smaller parcels.
Thank you. And I see that Jeanette sort of had a tag along comment. indicating that it's unfortunate that as a society we can't really ensure that farmers can have security in their retirement for family, and at the same time ensure farmland preservation. And so the question is, any thoughts on policies that might do this or assist in any way so that farmers or heirs do not feel that they have to sell?
I think so, like in my case where I'm specifically dealing with the states, Jeanette, in this like in my context, the issue, and something that I'm really hesitant about is, like, I understand when an estate trustee comes to me and they want to sell a piece of farmland under value to ensure that it stays in the family and is keeping for productive use. But the issue is that if they sell a piece of property way under farmland, they open themselves up to be sued by a beneficiary who would have preferred to see it sell for maximized value. And right now, like, the law supports an estate trustee being sued. And so I don't know, I feel like it could be a slippery slope, which is why I'd be hesitant to recommend it. But I feel like maybe in some instances it'd be appropriate to offer some sort of protection or government incentive to sell farmland under farm value so that it's staying in like productive use or staying within a farming family. And so that, an estate trustee isn't opening themselves up to being sued.
Thank you, Jenna. And maybe I'll ask David a question now as well. This sort of relates to something that came up yesterday during a panel on sustainability. And in essence, it was indicated that as climate change worsens, there's going to be a lot of agricultural land that's becoming available, or I guess land that's going to be now brought into what would be prime agricultural land. And I'm wondering if the ALR has given that any thought, or like the Land Commission has given that any thought as to how, they'll deal with it before it becomes an issue, or if there's any advanced thought or planning on that.
Yeah, I guess how agricultural land is used is more going to be affected more by climate change rather than the availability or presence, existence of agricultural land. So back in 73, almost all agricultural land, so every class of land under the CLI from 1 through to included some 7 as well, which is non-arable or non-farmable lands. So all of that land in effect, I mean, there's some missing, but it's fair enough to say that all land with agricultural potential in BC was already designated under the ALR. Some has been lost, of course, over time, but the land base was already secured. So the ALR itself won't have to adjust under climate change. The farmers will. But having said that, let's flip it around. So Quebec and Ontario are the only 2 provinces that have reserves their agricultural land. So it's for every other province, especially Ontario, where climate change is going to haunt everyone. And maybe I'll tie this line of thought back to what Jenna was saying. And it is, as everything changes, as farmland becomes more valuable to society, not just to landowners. And the concept of farmland protection, I'm flipping around here. Back in 73, when British Columbia established the ALR, it said farmland is different. Land with agricultural potential is different, and they identified the same issues then. It's worse now under climate change with increasing populations, the housing crisis. So it's this underlying principle and question for society as a whole, and this is where I tie it back to Jenna's comment in terms of even the succession planning, in terms of it's not just real estate. It should not be just real estate, but our society treats it as just real estate. And I guess you can hear it maybe a little bit in my voice, but why I just have really been caught up in farmland protection policy. It really strikes at this underlying question that should override other considerations. We see it popping up with applications for subdivision or severance of agricultural land, but right down to debates and contestations over wills. So it's an interesting process, but there's some bigger questions about agricultural land that society, our nation, needs to ask.
Yeah, and I think like maybe Jacob touched upon this a bit. Like there's no ALR the same way that there is in BC and Ontario. And I guess Jenna, with what you see and with the amount of sales that have to happen, do you see a lot of like farms that have now been converted to other use, or they're no longer kept as agricultural lands when they have to sell in these situations where they haven't had adequate succession planning? And
Only one so far, which I think is good news, but also a lot of these files, because they're so new at our office, they're still in limbo, and so I haven't seen resolution. Yeah, so some of them we've seen other farmers in the community come together and buy them and then lease the land back to the family so that they could keep farming. I've seen that happen in a couple instances, but so far out of my files involving farmland that I've resolved, I've only seen one that's gone to a developer, and that was in Peterborough. I will caveat that though with that the farmland itself, it had not been taken care of very well in the last few generations of farming, and it needed a lot of environmental remediation if it was going to continue as a farmland use. So it wasn't necessarily a loss of really prime agriculture, but still, and you know, like I have some people who call my office and they've had this family farm's been in their family since the 1800s, and now it looks like they're going to lose it, and they have really deep emotional connections to the land, and I don't think you can qualify or quantify that type of loss.
yeah, and it sounds like it's in flux, and it's hard to even get agreement within the family nucleus. So you as the lawyer, you're kind of left. I mean, you have your client, but you're left in a difficult situation. And then another thing that sort of came up, and anyone can feel free to jump in or throw questions in the chat or raise your hand. But this two-part system in BC seems to have basically been set out to allow farmers to basically support their families with other income. And I'm wondering if you see that in your practice, Jenna, where people are, you know, sort of being a bit squashed and they need to have other forms of revenue or make money in other ways, and they're not permitted to do that on agricultural lands in Ontario?
No, you know what? A lot of my farming clients, they have solar panels on their property. They are allowing easements for telecommunications, which they get annual payments for. Yeah, so I do see other uses happening on those pieces of property. I think here, like, property has just gone up so exponentially in price. Just for as an example, not even farmland, but a different file of mine. You know, somebody bought a house 5 years ago for $185,000. Now they owned it as tenants in common. They now can't, like, one wants to sell the house, other one wants to stay in the house. Well, the issue is the house is now valued at 1.1 million. So what do you do with that? Like, it's just, I think wages and the amount of money that people are able to earn just hasn't kept up with the cost of land out here. It's a huge problem. I think it's a huge problem everywhere, but it's a huge problem here.
Yeah, and that probably requires so much thought and so much planning to just basically allow these individuals to split their ownership within the property.
Mm-hmm. And like, I don't know, like, how do you, like, no one, like, I know property is generally considered to be like a really good return on investment, but I don't think people saw that, like, thought that their house was going to increase in value from 185,000 to 1.1 million dollars in a matter of a half a decade. I don't have any experience in that, Jacob. I have some experience doing cooperatives. Just I helped run a legal aid clinic for farmers and food businesses in New York for a year while doing my LLM down there, and I set up several cooperatives for farmers while I was doing the clinic. But I actually haven't seen any sort of cooperative models come across my desk so far at the firm I work at. I don't think cooperative models are as common here as they are in the States, just generally speaking.
And I actually have another question for David, just about the ALR generally. And I guess it seems like it's maybe like a permissive and prohibitive system and not necessarily a requirement-based system. Like, I don't know what they require you to do with the land that's in the ALR, but I'm assuming that you're not allowed to do certain things and you're permitted to do certain things, but maybe no strict requirement to sort of farm. And I guess when you look at these competing ideals that were in that 2-zone system, so maybe like preserving agricultural land and then permitting farmers' families, as the government seems to have put it, to make additional sources of revenue so that they can keep farming. I wonder if that sort of plays into it when you have people who may, want to be living on land or farming on land in the ALR, but need this additional source of revenue. So then you've kind of got these competing interests. And I understand that it wouldn't mean that they couldn't farm, or that they'd live there and they'd have to farm or in that sense be required to. But I guess how you kind of fit those together as maybe them needing this additional revenue to be able to farm. And so it does, in essence, further the objectives of the ALR, if that makes sense.
Yeah, the regular requirement piece is not in there. So it's definitely not required. The ALR, ALC is established just for the land itself. And it's part B of section 6 is to encourage the use of farmland for farming. That's about as close as it gets there. BC government has a whole section on strengthening farming, which is all about supporting the farming operations and everything else. But the commission, while it has section 6 is to preserve agricultural land, in its decisions, it considers the suitability of the land base, potential impact on the ag sector. Those are the two dominant ones, as well as the quality of the land. So every application is an interesting little story in that they will look, and they do look at the specifics of the parcel, and they will, it's almost for sure that if it's prime agricultural land and it's highly suitable, you're not going to get your proposal approved if it's for a non-farm use. And as a principle, they don't automatically say that they don't consider the farmer's well-being. That's an overstatement. It's an unfair statement, but they literally don't care about the farmer's well-being because 50 years now, they've been seeing so many promises. Oh yeah, if you let us subdivide, we'll develop just a little bit of this piece, and the income we get from there will help us to generate or really build up a farm over there. And they learned early on that you can't do any promises, and they simply can't even evaluate the farmer's ability. So all of those personal aspects are not considered. They can't be considered. Literally, it's really about the land base. But within that, you will see flexibility within the system where they do consider there's a part of the parcel that is class 6 land and it's rocky and really useless and has still road access. So yes, we will allow a non-farm use over there, and the potential for non-farm income will be helpful for the farm. So you see a flexibility accommodated in a lot of decisions, but it's wholly based on the parcel's considerations in terms of its suitability primarily.
Okay, I take your point. Yes, it's something that comes into play, but they can't necessarily go off what they've been told, and they're a little more cautious about how they deal with specific parcels on the land.
Yeah,
that makes a lot of sense. And then a question that I think Tara, I don't know if she is on this call, but she posted in the last session, and I thought it would be interesting to sort of canvas. And she said that thinking about local regulations and policies, how might we start thinking about zoning or policies for sustainable agriculture? And she's, I guess, sort of raised what you had said, Jenna, about the fact that she said, I know someone who is being told by a municipality that in the agricultural zone land, small farms are not permitted, only large farms of about 100 acres. And how might we think about shaping zoning bylaws and policies in a way that is supportive of different scales of farming? So I'm not sure if either of you can comment on that, or what she's getting at there about this middle ground.
Perhaps I'll jump in.
Yeah.
Again, ALC has same message, 50 years of experience of dealing with this. They get so many requests, proposals for subdividing. Again, I think Ontario and others place its severance. But subdividing makes small parcels, and almost every municipality or regional district will have minimum parcel sizes. It's a pretty standard statement in every rural area. And the ALC, the commission, will generally not go below that. And there's an argument where larger farms tend to be more likely to be farmed and better farmed depending on the part of BC you're in. But they, small parcels overall is essentially it's one giant leap towards loss of farmland. So as a starting point, it's an absolute no-go within the ALR in BC. We're looking at a less than 5% of the agricultural land base is suitable for farming, and less than 1%, I think only 0.1 is class 1 farmland, and that's most of Southern Ontario. We only have a tiny fraction here in BC. So subdividing it's a no-go.
So yeah, it sounds like not viable, and people don't continue to farm those lands when it gets below a certain size. And maybe Jenna, I'll let you hop in.
I think part of the issue with when you subdivide lands under 100 acres is that you can very quickly come up to max capacity for that land, and maybe the math doesn't necessarily make sense in terms of viability of farming on those smaller parcels. And I'm not saying that for everyone. Like, we get a CSA from a small farm in our area that was able to get a severance, and they do farm on less than 100 acres, and they have great success with that. But I think from kind of supply, like food supply perspective, I think also then you have, grocery stores and food retailers having to deal with a lot more smaller people, and how do you guarantee quality and conformity across all of those different smaller farms? It kind of I think the other issue is that the way our food system is set up, by allowing those smaller parcels, you're adding extra layers of complexity to maintain the food system as it currently exists. And I think that I don't know, that's just something I think about. But we have the same rule in our area, like less than 100 acres, it's usually a no-go. Our CSA farm, they were able to get a severance, but it's because they had been farming the land, part of this bigger farm, for 6 years, and they had a track record of farming on the piece of the property that they wanted to sever off. And so they were able to get consent for that because of that track record and the fact that they're known farmers in the area. But not everyone's in that not everyone's in that situation. So I think that's an unusual situation.
Victoria, maybe I'll add a bit more. I just want to acknowledge that this line of questioning about small lot agriculture it's almost the issue or interest in supporting new farmers and small scale farming. This is where farmland protection policy generally is seen as completely stifling small scale new farmers, barriers to entry. So it's almost, it seems irreconcilable. But one of the facts that the ALC points out is that there is a lot of small parcels in BC, for example. There's actually a lot of them out there. So it's not a lack of supply, it's more about cost. But one step that the ALC or the government did change the ALC Act a few years ago, and I must admit I've forgotten it. I don't know the status right now, but a few years ago, they introduced the ability to do long-term leases. So not just a short-term lease, but a long-term lease for new farmers primarily. And it was in direct conflict with the Land Act, which said that long-term leases beyond 3 years was actually considered a subdivided or severed parcel. So they were actually in conflict with each other, and they knew it, and they just put it forward anyways. But I don't know how well it was picked up, but it was specifically to address this new farmer entry without having to subdivide a parcel.
Mm-hmm.
Yeah, it sounds like that's a point of tension, and it seems to be that there has to be trust that people are going to I guess, do the thing that they say they're going to do with the land, and then can they afford to if it starts to get too small? So really important considerations there.
I think the other thing is too, at least in our area, a lot of farmers still live on their farm. And so when you start subdividing, like, are you going to start building individual houses on all of those parcels and then having to comply with like minimum distance setbacks and all of that to agricultural use for those houses and then take more land out of production? Or are you going to have a bunch of people who live, like I live in one of the towns, and am I going to live in town and drive 35 minutes every day to this piece of property I happen to farm at? That's other thing.
Yeah.
David's shaking his head. He's like, yeah.
Feasibility components. Yeah, a lot of practical realities. And I see that we're a minute over, so I won't keep you any longer. But this has been such an amazing panel. I know that I've learned a lot, and I'm sure that our audience will feel the same. So thank you, Jenna. Thank you, David. Thank you, Jacob, who's already gone. And thank you to everyone for joining on this this sunny Saturday, at least over here.
I'm driving home to 10 centimeters of snow. So
Ooh,
Oh, I don't envy you that.
no.
thanks, everyone. Thanks, everyone, for
Thank
attending.
you.
Thanks,
Thank you
Victoria.
very much.
Great rest of the day.